Assalamualaikum warahmatullahi wabarakatuh. We are still discussing the topic of content of the contract. Okay, this is part 6 already. So we have come to this particular subtopic, which is meant to cover or to discuss assumption or exclusion and limitation clauses. All parts are important, but this is very, very important. Okay, for the big topic. Okay, let's go to the definition first. Okay, let's get to know what it's all about. What is assumption clause? So, assumption clause, it refers to it refers to a clause which is inserted, which is incorporated into a contract. And what's the aim? It aims to exclude or limit one's party liability for breach of contract or negligence. I mean, yeah, if there is any breach, but the liability of the party is excluded or even is limited. It depends, okay, on that specific clause here. And then usually this clause will be inserted in many categories of contract. And one of them is standard. We call it as standard form contract. So if in a standard form contract, it allows a party to exempt himself from a particular liability or limit himself of the liability. If exempt totally no liability at all, or just limit the liability to a certain extent. Okay. So by a clause, how does it happen? By a clause inserted in the contract, which would deprive the innocent party of certain remedy, okay, when the contract is breached. So that's why the clause is either in the form of exclusion, to exclude, to exempt wholly, or to limit, okay, to certain extent, okay, or we call it limitation clause. It's either exclusion, exemption, or limitation clause. And this is the definition of standard form contract. Okay, what is standard form contract? So for example, each time a person, okay, we travel on the public transport, for example, or if you buy electrical item, so the party, okay, the customer will receive a standard form contract. So the party receiving it, okay, must either accept all the printed conditions in totality or refuse to contract. It's either you use the public transport with the printed ticket, ticket printed with exemption clause, or you don't use the transport at all. Okay, here we cannot really negotiate. That's why it is called standard form contract. You cannot negotiate. Oh, I don't agree with this term, with that term, cannot do so. Okay, so the party delivering the standard form contract. Sorry for the spelling error. Standard form contract may insert certain clauses in the contract unfairly. So in that sense, okay, it unfairly exempt him from certain liabilities. So these clauses, you can find it may appear in printed tickets, notices, receipts, which are brought to the consumer's attention at the time of the agreement. I mean, here, we must be aware of these clauses, okay, when we enter into the contract. But again, as far as Contracts Act is concerned, there's no provision which talk about exemption clauses. So we are going to refer to cases, including cases at common law. Okay, when we talk about the categories or classes here, okay, there are three, okay, at least three. Okay, broadly, there are three categories of exemption clause by virtue of this case. The case is Tavichai Marina, 1995, reported in MLJ here. Okay, let's have a look at the categories here. Three categories of exemption clause. Okay, the first one, clauses which purport, okay, to limit or reduce what would otherwise be the defendant's duty. For example, by limiting liability to cases of willful neglect or default. Meaning that here, we are not responsible unless it is because of the willful neglect. Okay, I mean purposely neglect, okay, or negligence, okay, on the part of the defendant. The second one, clauses which purport to exclude or restrict liability which will otherwise attach to a breach of contract, okay, such as liability to be sued or breach or be liable in damages. I mean, they exclude liability. No liability. We are not responsible to pay compensation, for example. Okay, that's the exclusion. Or sometimes we are paying you up to certain amount. That's the limitation. Okay, limitation clause. Okay, number three, clauses which purport to exclude or restrict the duty of the party in default, okay, fully to indemnify the other party. Okay, for example, by limiting the amount of damages, the example that I gave just now, okay, recoverable against just now, the ability to take action, okay, the number two here, right? Okay, this is important one. Okay, what if plaintiff, okay, the victim, the one who suffer losses, did not read or understand the exclusion clauses? Can you buy something and then you say, oh, I don't know that there's exemption clause whatsoever. Okay, or maybe I don't know that the seller, okay, the other party is protected by this exemption clause. Can you argue that in the court of law? So this is the answer. If the plaintiff signs a document having contractual effect containing exclusion clause, it will automatically form part of the contract. And the customer, the one who signed it, he will be bound by its term, despite that, even if he has not read it, or maybe he read, but he didn't understand it. Okay, that's not, I mean, the court won't simply accept the argument. Okay. So ignorance of law is not excuse. If you read, you don't understand, then I mean, the court won't simply bother. I mean, you are taken to take it as a whole. Okay, you are being obliged by all the terms that you have signed. Okay, we have a very classic case here. This is common law. The case is Lestrange, okay, and Grocop, 1934. This is to show to us how the court apply application of the rule pertaining to exemption clause. So plaintiff bought a cigarette machine for her cafe from defendant, and she signed a sales agreement, okay, in a very small print, and she didn't bother to read it, okay, without reading it. Actually, the agreement contained, okay, it provided that any express or implied condition, statement, or warranty is hereby excluded. So there's no warranty whatsoever, okay, with regards to the cigarette machine here. So the machine failed to work properly, and later plaintiff brought an action for breach of warranty. But the court held that defendant were protected by the clause, because the clause provided that they are being excluded. Whatever warranty, they are being excluded. So that's how exemption clause operated or worked. And this is what the judge said, as Cratton LJ here said, when a document containing contractual terms is signed, then in the absence of fraud, I mean, it's not a case of fraud whatsoever, or even misrepresentation. So the party signing it will be bound, okay, by the terms here. And it is not relevant, it is wholly immaterial whether he has read the document or not. Okay, that's the rule governing or principle in relation to exemption clause. Okay, but because the effect of exemption or exclusion clause is to exclude or exempt liability, so there are conditions and requirements so that it can be operative. It is valid and enforceable if all the conditions or requirements are fulfilled. So here, in a way, it is quite balanced here. Okay, the first one, okay, very important. Notice must be reasonably sufficient. Meaning here, the other party who signed it, who accepted the clause, must be aware of it. Okay, for example, in the case of Parker and Southeastern Railway Company, 19th century case, a very old case, classic example here, 1877 common law. What happened? Plaintiff deposited a bag in a cloakroom at the defendant's railway station. So he received a paper ticket which reads "see back." Meaning here, if you receive something "see back," you have to see back. Like you have to read what's printed on the other side of the ticket. So on the other side were printed several clauses, including, okay, the relevant one, the important one, which affect his right later. Okay. His right later. So the company will not be responsible for any package exceeding the value of 10 pounds. So this is what we call as limitation clause, meaning a certain limit to the payment of compensation later. So plaintiff presented his ticket on the same day, but his bag was missing, could not be found. So he claimed the value of the bag, basically, okay, the total losses here, 24 pounds 10 shillings for the value of the bag. But the company pleaded, no, we are going to pay you up to 10 pounds only. Okay? The company pleaded limitation clause in defense. And this is the decision, observation by the court here. So in the Court of Appeal, the judge, Malish LJ, he gave the following opinion. He said that, okay, if the person receiving the ticket did not see or know that there was any writing on the ticket, then it's not bound by the condition. Meaning that he doesn't know about it. He didn't see it, okay? But if he knew there was writing and knew or believed that the writing contained conditions, then he is bound by the condition. So it goes back whether he knew about it or not. And if he knew there was writing on the ticket but did not know or believe that the writing contained conditions, he was still bound, provided he knew about it. Okay, it doesn't matter whether he read or he understand or not. Okay, that's basically the rule or principle here. And then remember, the notice must be reasonable. So what's the meaning of reasonable here? So again, it is a question of facts. It depends on the circumstances. Okay. And the courts have repeatedly held that attention should be drawn to the existence of exclusion clauses because it affects the parties' right to claim later, okay, by clear words on the front of any document delivered to the plaintiff. Example, for conditions C back. Here, so by putting these printed words here, so the party is aware, oh, there are conditions attached to the transaction whatsoever. And then it seems that this is from the case law from Thornton and Shule Party. It seems that the degree of notice required may increase according to the gravity or usualness of the clause in question. So how it depends on how grave or the extent, how extensive the exemption clause is. Okay, for example, in the case of Thornton and Shule Party, 1971, what happened was that, sorry, itchy nose this one. Sorry. This morning. Okay, plaintiff drove into the defendant's car park and he was given a ticket, okay, by an automatic machine. This is something which is common, okay. And on the ticket, it stated that it was issued subject to conditions displayed inside the car park. And the conditions inside the car park were in small print. This is a small one. You cannot, it's hard to read it, okay. And one of them, okay, excluded liability for damages to vehicle, okay, or injury to customers. Plaintiff was injured due partly to defendant's negligence, but plaintiff was not held to be bound by the notice displayed inside the premises. Why is that so? This is the observation by Lord Denning. Okay, he's very critical and analytical. So he said that the clause was so wide and destructive of rights that, that here it's like it exempts the whole no liability at all. So the party must be aware, must be made to aware of this. So the Lord Denning said that in order to give sufficient notice, in order to be considered as reasonable notice here, it will need to be printed in red ink, okay, with a red hand pointing to it, or something equally startling. Okay, meaning that here the party must be aware of this very destructive exemption clause. Okay, meaning here he doesn't have the right to claim later. He must be made aware of it. Okay, another condition we continue later. Okay, I stop here. This is the second condition of exemption clause. Assalamualaikum warahmatullahi wabarakatuh.